I want to first announce Anthony Garasi. He is a partner at a local law firm here in Las Vegas. He's our real estate litigation expert on the panel. He has a civil defense firm that he is a partner at. He handles a variety of different cases filed against agents and brokers, so he's going to offer that perspective. Next, and probably the most graceful of the panelists, also my wife, Rachel Mihai. She is going to talk to us about mediations and arbitrations. She's done numerous amounts of both of those items. She's going to get into the nitty-gritty of what they mean, how much they cost, how long they take, what's the better option. So thank you, Rachel, for joining us. And I'm really excited to get Mark Sterbcow here. He comes to us from Louisiana. I took a late flight yesterday. Thank you for joining us. He is a sort of our expert on RESPA and the Consumer Protection Financial Bureau. So we are very lucky to have him. He's a very specialist in that area. He travels a lot to Washington, D.C. to get the ins and outs of what's going on with our governmental bodies that are regulating our industry. So he is going to provide a lot of great information for us. Okay, with that, let's just get into it. I'm going to start with Marx here. I'm going to just ask Marx to tell us generally who is the CFPB and what's the latest and greatest you're hearing from them.
Sure. How are y'all doing today? Make sure this isn't too close to me. The CFPB is the Consumer Financial Protection Bureau. It was formed back in 2010, and it is the regulatory body that's now in charge of anything related to mortgages, whether they be residential mortgages or installment land contracts or just a myriad of different things. The Bureau at this point has around 2,000 between 2,000 to 2,500 employees across the country. It is it's a regulatory body that is very pro-consumer focused, so that they're not a big fan of the industry. They don't take a lot of guidance from the industry, but they do from the consumers. And if anything that harms the consumers, the Bureau is going to step in, whether it be the Real Estate Settlement Procedures Act or the Unfair, Deceptive, Abusive Acts and Practices, or which is called UDAP. Just a myriad of things, and they have at the same time contracted in or signed agreements over the last few years with just about every state attorney general's office in the United States, the Department of Insurances, the financial regulators, and even some real estate commissions, from what I understand.
Marx, when did the CFPB start?
In 2010.
Okay, and why did the government form the CFPB?
The government formed the CFPB after the collapse, basically, of the real estate industry from 2007, 2008. What was happening is you had a myriad of different regulatory agencies, and they didn't really do a good job of policing. And then you had the RESPA division, which was under HUD's control. At its height, there were 25 people policing the entire United States. The Bureau doesn't have that lack of number of employees now. They have a tremendous number of employees, and the other difference is that they do get 25% of the take, unlike the old RESPA division.
Yeah, okay, so let me ask you this. Should we be worried about the CFPB, and why?
I would say if you're a real estate broker, real estate agent, you should be petrified of them. Initially, but I think they're practices and things that you can put in place into your operations so you can sleep very well at night and not have to worry about it. One of the biggest, the newest thing that's coming in that everyone really needs to be very cognizant about is TRID. Page 5 of the closing disclosure form now requires real estate agents and real estate brokers all their contact information, their addresses, their phone numbers, their license numbers. And the reason, not just the real estate agents, but also the mortgage brokers, the lender, the title and settlement company, the reason that they're asking for that information is there's a new regulation that's coming into effect in 2018 called HMDA, the Home Mortgage Disclosure Act. That is the tool that the CFPB will be using to basically collect data on every single financial transaction in the United States. So they will know every party, that has done every single transaction with who and what the amounts are, and they basically will be data aggregating it. So if there is a complaint, consumer complaint, they can come in and look at their new database that they've established and use the data to come up with an enforcement action. So it doesn't have to be a physical agreement that, you know, I gave money to Alex over here. They're now using data, statistical data, to show that there was a violation of RESPA.
So, Marx, if the CFPB were to send a subpoena over to one of our brokers or affiliates here, besides just freaking out, what do we do? What do we do with that subpoena? They want a bunch of information. They want us to gather stuff, essentially an audit that they're trying to do. What's the initial step we take?
The first step you need to do is contact a qualified RESPA or CFPB defense attorney ASAP, because there are very strict timelines that of response that you need to respond to. Those responses are very expensive. I represented somebody in connection with a case where it was an attorney who drafted an agreement for some companies. And for that attorney just to respond to the civil investigative demand, which is called the CID, that was $56,000. And more often than not, insurance coverages do not cover that, so that came out of his pocket. So it's something you have to be very cognizant of.
Okay. I'm going to come back to you because I want to get into some recent investigations done by the CFPB and what resulted from those and penalties that were issued. But before that, I want to move to our next speaker, Ms. Mihai. So mediations and arbitrations, they kind of go hand in hand with the practice of real estate. I know that one of the reasons that I love the real estate world is because of the entrepreneurial spirit that we have in this room. We're all good negotiators. We're all very good, whether we know it or not, working with people. This is a people business. And from my experience, a lot of these issues, claims, grievances that a seller or buyer may have get resolved pre-litigation, and that mediation and arbitration sort of come into play. Tell us what's the big difference between a mediation and arbitration? I just want to make sure that we're all clear on what these terms mean, and then we'll get into some more detail.
So typically, there are non-binding arbitrations, but an arbitration and a mediation are going to be primarily different in how formal they are and what it requires you to do as an outcome of going to either of them. So a mediation is going to be an informal setting. It's going to probably be a day usually. You decide on a neutral, which is a mediator, usually an attorney or a retired judge, with the other side that you're going to this mediation with. You hire him for a day. You it's usually in his conference room, you bring all of your information and documents and facts. You go and usually the mediator will have you in two separate rooms. You present your case, and the mediator will come back and forth between the parties and try to get the parties to a place where they can come to an agreeable resolution to their dispute. It's not binding, so there's no judgment made. You're basically hiring someone to help you come to a decision. Now, the mediator is not going to be someone who's going to, it's not a judge, it's not a jury, so it's not going to be someone who's going to listen to the facts and say, this is what I think the outcome would be if you went to trial necessarily. The mediator's job is to get the two parties to a point in the middle where they would agree to end their dispute. An arbitration, on the other hand, is usually, the way you guys would see it, is probably a binding arbitration, meaning it's a substitute for going to court and being in front of a judge and filing a lawsuit. So it's initiated by something called a demand for arbitration. One side has a dispute with another side, and so they send them this formal demand saying, I want to arbitrate our matter. You, similar to a mediation, come together and determine an agreeable arbitrator, which is usually a retired judge, sometimes an attorney. That arbitrator, it usually happens over the course, it can vary, but maybe a year. You'll see it maybe sometimes less in the real estate world. You can do it quicker, maybe 6 months, where you'll have an exchange of information between the parties. Maybe you'll exchange documents. You might have some depositions. You may have a mediation along the way to try to resolve before going to this binding arbitration, but it leads you to this, the eventual end is this hearing in front of this arbitrator, usually in a conference room or his office, where he hears both sides present their facts and makes a binding ruling for the sides, much like a judge would do if you were going to go to a court in a lawsuit.
How much does the mediation cost? A full day mediation, what's the typical cost?
So it varies. Mediators, you know, I'm always said I'm in the wrong profession, and maybe one day I need to be a mediator because they can make anywhere. You'll see mediators that charge maybe $200 an hour, but you can see mediators that will charge, you know, $1,000 an hour. It really depends on the mediator that you use. Sometimes they charge by half day, full day. I think you can expect to maybe pay around $3,000 to $3,500. I know that the California Association of Realtors, the website has a really great resource actually for mediations. They have a form that you can fill out to request a mediation, and then they have a list of approved mediators that are experienced in real estate, and I think they charge, through that program, I think they charge $175 an hour for the first 2 hours, and then it's anywhere from probably $200 to $500 an hour after that. And so you're going to have them for a full day. In addition to that, the costs are going to be, usually you're going to want an attorney involved, which that might be another question that's coming up. But you're going to probably have to pay an attorney to prepare for that as well.
So mediation, in my experience, you've got a mediator there. He's not there to be your buddy or anyone's buddy. He's going to look good if he gets cases mediated, and he can show that on his resume. I mediated 1,000 cases or whatever cases to resolution. So he's going to make you feel terrible about your case. Okay, that's his goal. He's going to make you feel like crap. He's going to make the other side feel like crap. And then if both sides feel shitty about their case, they're more likely to reach a resolution. That's kind of what a mediator does in my experience. So I don't know if that's true or not, but that's been my experience. So if you're going to go to mediation without an attorney, without counsel, and I know it happens, we have brokers and agents attend these things, and that's okay. Go prepared, get all your files together, and just go in there with the understanding that they're going to make you feel terrible about your case. And that's the only way they can kind of bring your number down or get the other side's number up. Otherwise, if you feel great about your case, the other side feels great about their case, they're going to say, well, why the hell would I want to mediate? I got nothing to lose. I mean, no one's telling me that I got any holes in my case. So that's kind of mediation. Would you recommend, in your experience, sort of for brokers and agents to go unrepresented mediations? Is that okay? I know in arbitration it's a little bit different because you have a binding judgment, but this wouldn't be binding. And if so, if it's okay for them to go unrepresented, what kind of tips would you give our audience and tools so they can be best prepared?
So I think you should hire an attorney probably if you're going to go to a mediation, but that's my job. From an unbiased perspective, though, truly, I think that there's a big cost benefit to having an attorney prepare you for and go to a mediation with you. You know, as Alex said, the mediator is solely concerned, no matter how. Sometimes some mediators make you feel warm and fuzzy, and some mediators make you feel really bad about your case. They have different styles, the different mediators, but. Putting all that aside, a mediator is successful if he gets the case done, and he or she will want to get the case done at whatever cost. So, you know, if you go into a mediation and you're unrepresented and the other side is represented, you might be at a little bit disadvantage where the mediator's not your friend, he's a neutral. And the mediator might take advantage of that situation, and you might end up getting the short end of the stick on the resolution on you know, wherever you come to. It might, so you want the sides to, the one side starts at A, one side starts at Z, and you want the sides to come together and ideally be at 50%. The scales might tip if you're unrepresented. And the reason I say that is this, you know, every single case is gray. I don't think, you know, I don't think there's no case that is 100% either way, and I think if anyone tells you that, then it's just, you know, that attorney is not being truthful with you. There are always bad facts and there are always good facts in a case. If you have somebody who can represent you and know the implications and the effects of good and bad facts, they can choose the facts to display to the mediator and to argue to the mediator with keeping sort of the bad facts to the side. And I think if you go without representation and you don't know how the facts may play, down the road or how may implicate you in the end, I think that, again, a mediator will pick up on that if you didn't and use that against you. So I think you want to go with representation to a mediation.
Okay. We'll take some questions in just a minute. I'm going to kind of break it up a little bit. But I want to go to Anthony first. Anthony is a litigator here in the greater Las Vegas area. His office is in Summerlin, I believe. Right. And you're in courtrooms, Anthony. You're in courtrooms and you're hearing what judges are saying, what jurors are saying, and what plaintiffs are saying in terms of the types of grievances they have with brokerages and agents. Tell us just generally what kind of claims are you seeing more often than not being raised in a lawsuit against brokerages and agents?
Sure. Thanks, Alex. And thanks for asking me here. Litigation is supposed to be the last resort, right? You're supposed to have the informal discussions, and if those don't work, maybe you do the mediation, and those don't work. And then the complaint's supposed to be the last resort. In California, in fact, there's a lot of cases where arbitration or mediation is mandatory. In Nevada, that's not the case. You might not be on notice of any of these claims until some process server comes and hands you a complaint and says, you have 20 days to get an answer on file. And then you're scrambling by needing to deal with it, maybe needing to put your records together, maybe needing to hire an attorney, definitely moving it up the chain of command in your office. And those sorts of suits, the typical suits here in Clark County and in Nevada and all over the Southwest really are really what you expect. Failure to disclose suits. Negligent undertaking suits, meaning you, the agent, wasn't properly trained or properly prepared to handle this suit. Those typical breach of contract, the buyer or the seller had an agreement with the agent or the broker and something in that agreement was not met. And those are the claims, and Alex is right. Litigation it can be scary also. I mean, it's not like a criminal case. In a criminal case, there's an officer who has to determine probable cause, and then he gives it to the DA, and then the DA reviews all the information, and he decides, all right, this is worth proceeding. Then you give it to the judge, and the judge maybe does an evidentiary hearing or something to determine the facts himself, and after all that, a criminal complaint is filed. Well, civil litigation is different. There's none of that in civil litigation. In civil litigation, you have to have $400 to file the complaint. Maybe you hire an attorney, maybe you don't, but you'll draft up the complaint, pay the filing fee, and then pay to get it served. So there's no fact checking. These claimants can put whatever they want in the complaint, and they serve it on you as the agent. You see it and say, well, this isn't true, this isn't true, this isn't true, but they can still do it. And that's where the process, the internal process from you guys is so important. Making sure you're keeping documents, making sure you are moving it up the chain of command so your brokerage and even Alex is aware of these sorts of things, because once the complaint is filed, as frivolous and as nonsensical as it may be, it's on you now to answer and to prepare the defense and to work with the attorneys, the corporate attorneys, maybe outside counsel to prepare to fight this, because once litigation is filed, then the clock starts. Then you have times to do certain things. You have 20 days to answer. And then you have to appear and meet and confer meetings, and then you have to provide all your documents, and then maybe you have to prepare and appear for a deposition. And there's deadlines that if you don't meet the deadlines, the rules in Nevada and the rules all over say the judge can summarily decide the case. Maybe not on the merits, but maybe just for failure to meet a deadline. So once litigation occurs, it's important to follow the chain of command and do what you need to do and be prepared to do it.
So Anthony, one thing that I see come across my desk, and every E&O policy is a little bit different. So we all have different insurance coverage for what we do, but sometimes you'll get agents that list their own homes. So now they're essentially an agent/seller. And the coverage that I know our brokerage provides will cover the agent as seller in certain instances, okay? What's your experience been in that regard, and when does that coverage work for kind of both the agent/seller?
Yeah, and professional liability insurance is different than auto insurance, for example. Professional liability insurance has a ton of what's called exclusions, meaning you have coverage except in these circumstances. And sometimes agent-owned properties fall under an exclusion. Typically, and all the policies are different, but typically to get outside of that exclusion and to make sure the coverage is there, it's disclosure. Make sure that when you're doing the deal, everybody knows the relationship. I mean, that's the most important thing. There's really two things for you guys to remember. If you're gonna take two things away from at least what I'm talking about, full disclosure. Disclose as much as you can to everybody you think who might have any reason to wanna know. And then two, keep your files. Keep your documents, keep everything organized, keep everything, and not just the sale documents, but keep the emails, and keep the notes, and keep those sorts of things that might demonstrate things like disclosure. Like you might not have a formal document that said agent-owned property, but you might have an email correspondence back and forth and say, yeah, this is my house, you know, I did the flip, I acquired this, however I acquired this, I'm selling it myself. And that's sufficient for the disclosure. And obviously all insurances are different, so I don't want to say it's sufficient across the board, but generally that's the type of thing that triggers the coverage.
Yeah, so disclosure is important. So that's something we see very common in our world, and it's disclosing material facts. And material facts, the standard to determine if something is material or not is a reasonableness standard. It's an objective test. So what one person may think is material, the other person may not. But you're going to have a jury if it goes to a trial. And these jurors are likely not going to be professionals in real estate. And it's better to err on the side of disclosing it, so you don't even leave it up to the jury to decide if it's material or not. So if you have a big crack in the foundation, probably material. Ash stains around the electrical outlets, probably material. And then you have something more subtle. You might have just, I don't know, some crayon writings or something on the walls. Okay, that might just be a child doing that. It might not be something, you know, it's covered up by something else. So it's kind of up to you to determine, but always better to err on the side of, well, maybe I don't think it's material because I've sold a gazillion homes, but a juror who's never sold a home in their life may think it's material. So that's kind of what you have to ask yourself. Put yourself in the position of somebody that doesn't know much about real estate, has never sold a home. Would they think this item is material? And then disclose it. So I know in the state of California where I practice, we have what's called an AVID form. It's Agent Visual Inspection Document. And the agent goes through each bedroom, essentially the kitchen, and it's just laid out. Sometimes I'll see agents just leave it blank. I guess in their mind, they've gone through it and they haven't seen anything significant or whatever it is. Don't leave it blank, because the attorney's going to take that and say, now you didn't go through a single room. And had you would have written something down. At least room checked, nothing observed. Something. You didn't write anything down. And you're not going to recall if you went through bedroom 1 or bedroom 2, because now we're talking 2 or 3 years later. So identify something on there. Help your lawyers make arguments that you went through those rooms, you try to observe something, and there's nothing observed. And if you do observe something, just jot it down. So that type of documentation is going to be evidence. The only way to prove a case in litigation is through evidence. And what lawyers say is not evidence. They might say all the right things, but they need your testimony, and they need some documents to back it up. And if you already submit the paperwork and then you're still thinking about something, send an email. Send an email to the other agent and say, oh, I forgot to mention the downstairs bathroom had the base molding sticking out, or something like that, whatever it is. That's sufficient as a disclosure. It's an email, it's in writing, it doesn't have to be on a form. It's just disclosure. So they've got wind of it, now it's off your back. Okay, so went on a little tangent there, but I think it's helpful because we see those claims frequently. So do any of you guys have questions before we go to the second segment of our legal panel discussion? Yes, ma'am. Paperwork? Yeah.
Keep it. Yeah, if you're the agent and the seller, typically, well, there's different statutes of limitation is the key word. It's a lawyer term, right? It means the claimant has this long to file the lawsuit, or they're barred from it. And there's different statutes of limitations depending on different claims. For instance, a negligence claim is either 1 or 2 years, or a fraud claim might be 4 years. So to be safe, 7 years is always safe. Nothing is going to come along more than 7 years. So my practice, I keep my files 7 years. I think 7 years is safe. Realistically, if that's not possible, if that's not probable, no less than 4 years.
Yeah. Anything else? Over there, yes, sir.
The panel's been talking about contractual relations, and I'm not sure how far the CFPB goes. Does it? And you know, started after the debacle of Wall Street. And I don't know if you guys have ever seen The Big Short on the movie or read the book. A lot of the problems we're talking about here, not necessarily contractual relations, started on Wall Street. Does CFPB have any control about mortgage products that come out of Wall Street and get a review process before we start working with something that's wrong and we don't even know it?
That's a great question, and I will tell you that that any financial product the CFPB believes they have jurisdiction over, whether that be somebody actually involved in the transaction itself, or it could go as far as an advertising company or a television station. They have super broad powers, at least at this point, and but they are going after the bond rating agencies. There are some CIDs out there, and
Do they approve a new product before it goes on the street?
They will give guidance, but the guidance has been by enforcement. So their method of operation is not to give you written guidance as to what you can and cannot do. What they do is they basically go ahead and file an enforcement action or enter into a settlement agreement, and that's the new rule and regulation.
And a second question. You're talking about consumers. Are consumers only individuals? If we have a transaction between an individual and an LLC or a corporation, are those entities also covered under this, or is it just individuals?
It can be any individuals and entities. I mean, they have wide-ranging authority. Now, I will say that realtors are, real estate agents and real estate brokers are exempt from many of the provisions under that the CFPB has jurisdiction over, but they fall back into it under RESPA and UDAP. And right now, UDAP is more or less the stopgap measure for anything that they deem to be deceiving, misleading to consumers. They'll institute that. Now, one point I want to bring up is you mentioned consumers. The Bureau was designed to protect two different consumers. And most people think that the consumer is actually the person buying a house or the person selling their house. That's only one consumer. The real consumer that the CFPB was designed to protect are pension funds, hedge funds, international equity investors that buy mortgage-backed securities or any sort of private label security out there, because they're trying to bring that segment back into the real estate market. At the height, I believe it was around 42% of all mortgages were sold or were purchased by private investors. Today, that number is less than 2%. So right now, the government is doing they're basically backing almost 98% of all mortgages that are being issued today, residential mortgages. So they've got to find a way to bring the private sector back into it to relieve the government of a lot of liability.
So, Marx, what's the future look like with the CFPB? I know that we had a new administration come in 2008. There was a big movement at that time because of the state of the lending world and sort of what got us into that recession period to have more oversight. Things have kind of changed, and there may be a new administration taking over in 6 to 8 months. What is the future? What can you kind of predict in your crystal ball here?
I will say one thing, that the Bureau, they have built up this massive bureaucracy. It is under the jurisdiction of the Federal Reserve Board, so it's almost carved out of Congress's oversight. Congress has some oversight, but it's really the Federal Reserve Board with their unlimited funding.
So you're saying they can do whatever the hell they want to do?
Yeah.
They got money, they're just going to do it.
Well, I'll say that I do think that they have built up such a large bureaucracy of folks that are so consumer-focused that it would be darn near impossible over a short period of time to get those folks out and bring more of a balance back into it. It may be 6 or 7, 8 years before we see some sort of maybe balance, and that depends on who the administration is coming in.
So I know as recent as 6 to 8 months ago, you had Bank of America, you had Wells Fargo come out and say publicly, we're no longer going to enter into agreements, MSAs or whatever it is with brokerages. And the reasoning that I read, and I was trying to read in between the lines, was due to the uncertainty, okay, in the regulatory climate, we are no longer going to do X, Y, Z. What does that mean, and what's your take on that? Why are they sort of backing away?
So if you read the news, you see a $15 billion settlement here, a $1.5 billion settlement there, $7 billion here, 35 there. The shareholders for these publicly traded banks are scared to death. And so what we're seeing right now take place, not just in MSAs, you're seeing a withdrawal of the big banks across the United States from residential lending. So much so that some of the Kroll Bond Agency came out a few weeks ago, and they believe that the Big Four will either completely drop out of residential lending altogether, they won't do residential loans, or they will scale it back to such a level that maybe they just own a few jumbo products and things of that nature. We're starting to see that take place. I believe that Chase just sold their entire USDA arm off to Freedom Mortgage a few weeks ago, and there's some other things kind of taking place. But that's the main reason that the banks have pulled out of MSAs and other agreements. Are these agreements illegal? No, they're not. There's a specific exemption under RESPA Section 8C2 for goods and services that are provided and rendered that allow you to do it. Now, having said that, if you have a advertising agreement or marketing service agreement, it has to be designed for either mass marketing or mass advertising to the general public. It cannot be designed to facilitate advertising or marketing to people that are under contract. If you've signed a listing agreement, a buyer's representation agreement, or a purchase agreement, and that's the reason for the MSA or the advertising agreement or lead generation agreement, that's going to be illegal by the CFPB. It's got to get to the general public, through a mass advertising aspect. That's probably the most important thing I'll tell you. For any agreements that you have with settlement service providers, make sure it is to the general public, and so you make sure there's no access to sales meetings, or you get to meet with the brokers. They don't get to come in and provide donuts. In fact, I have a legal opinion letter from the regulators discussing donuts. It's my favorite. The question was posed to the regulators: is a donut considered something of value if a mortgage originator gives that to a weekly sales meeting? And the Bureau came back and said, yes, that is something of value, and we would enforce that. And so my advice for that is to make sure you don't eat the powdered donuts, because that does leave a paper trail. So just go for just get the glazed.
Okay, what else? Any more questions? Catherine. Yes, ma'am. Wally, microphone. Wally, microphone, please. Thank you. No breaks here.
Thank you. Mark, can you tell us, we've heard a lot about the CFPB with title companies, with mortgage companies. Can you tell us if there's been anything in the last year, any actions taken against specifically brokers or real estate agents?
There have been some actions. There was the Realty South and Title South case in Birmingham, Alabama, where somebody came up with the light bulb idea in their head to put in the contract that they must close everything with the real estate contract actually said you had to close everything with Title South. That has so many problems. It's out of control. So they hit them. I think the legal fees, I think they settled it for $500,000, but the legal fees involved in that from talking to people involved in the case, it was around $2.5 million, $3 million. There's a finite number of RESPA defense attorneys in the country. Those guys charge anywhere between $700 to $1,100 an hour. So it's a lucrative area to practice in if you do the defense side of it. Yeah, anyway, that's where I'm.
Yeah. Let me go back to Anthony in terms of the litigation world. I get calls from agents every now and then, not any agents in this room, but I get calls from agents, and they call me freaking out sometimes, saying, holy smokes, I'm in a lawsuit, I didn't do these things. They get very defensive about it, and it's normal. It's a normal reaction. What kind of advice can you give to brokers and agents named in the lawsuit where they're just obviously believe the allegations being made are just lies? Do people just lie for money? Is that kind of part of the way it works in litigation?
People do litigation for all sorts of reasons. Some people just want to blow off steam. Some people feel like they are, truthfully harmed, and some people see it as a quick buck, sure. It's scary when you're served with a complaint. And that's where it's important to do two things. One, make sure you move it up the chain of command. First thing to do, one of the things we didn't talk about with regard to insurance, but with professional liability insurance, if you're on notice of a claim, the clock for the insurance coverage begins to tick. So the first thing you want to do is report the claim to the insurance company.
How is a claim defined? What's the definition of claim?
Typically, a claim is a request for money. I mean, it's as simple as that. Whether the request is a specific amount of money or I'm harmed and it's your fault and I'm going to ask, for something from you, that is a little bit murkier, but they've got to make a request for some compensation from you. If they just send you a letter you'll often see is, there was this property, there was this damage at this property that you were the agent at, please preserve all your evidence. It doesn't say it's your fault. It doesn't say I'm asking for $1 million from you. It just says there might be litigation, you're under a duty to preserve evidence. I don't think that's notice of a claim. A claim is a demand for money. So as soon as you get that demand for money, now the preservation of evidence, you should also move up the ladder as well. But once you get that demand for money or demand for mediation or demand for arbitration or however it's worded, where they're saying, I'm coming after you for something, that's when the insurance company needs to be put on notice.
And what if you don't put them on notice? What if you just call that attorney back and say, what is this nonsense? What do you want from me? Go pound sand.
Well, and that's our inclination. That's an attorney's inclination. That's an agent and a broker's inclination because you are negotiators and that's your job. And you want to say, I'm going to call this guy up and tell him why he's completely wrong and tell him why I shouldn't be in this lawsuit at all, and I'm going to handle this on my own. Well, that might take a week or a month or multiple months, and if you don't report to the insurance company, the errors and omissions professional liability, the insurance company, in whatever their time frame is, they might say you're barred from coverage. So then, if you can't resolve it with that other attorney, now you're left defending the suit without any insurance coverage.
Yeah, that's kind of a very fine line to walk because I'll get certain letters. Folks will be yelling and screaming about something. It's usually a plaintiff's lawyer that wants money, and I'll call the agent up. I'll get some facts. I'll kind of figure out what's going on, or one of our brokers will do that. But the decision that I tend to struggle with sometimes is does this need to be reported to insurance? Okay, because obviously the more you report to insurance, the more your premium may go up. So as brokers, you want to keep your premiums down. You want to be careful of that. But what I do that helps me in my world is I have a legal report that keeps track of all these lawsuits that I have, mediation demands, and things of that nature. So I know when my coverage period expires. And if there's something in the mediation world where there's a demand for money made, I'm not going to just let that run and let my policy run. So before say the policy expires January 1st, and these haven't been resolved, I will tender a week in advance, and I'll just put the insurance company on notice so I make sure we have coverage. What you don't want to do is let it go and never report it, because then if there is a lawsuit, you're going to pay the defense fees out of pocket, which Anthony will tell you will be thousands. Okay, so maybe your deductible is $5,000, $10,000, I don't know, $15,000. It's going to be a lot more than that if you have to litigate. And you're going to be under more pressure, and you're really going to pressure the attorneys to do things that maybe they typically wouldn't do because you don't want to spend as much money. You might want to just kind of mediate really fast or resolve really fast. So
Yeah, and like we talked about earlier, there's a lot of different types of professional liabilities policies, but one type is a policy called a made and requested policy, which means if you get a complaint or a claim, notice of a claim, you as the insured get a notice of a claim, you have to advise the insurance company within that policy period, not just that the claim was made, but that you've told the insurance company. So let's say your policy runs from January 1 to December 31st. If you get notice of a claim on November 1, you only have until December 31 to notify your insurance company. If that next policy period begins, that's when you are precluded under the policy, in theory, from benefiting from that coverage. So that's why it's important to know your coverage, know your policy period dates, and know what type of policy it is. If it's a made and requested policy, you have to put the insurance company on notice before that policy period ends.
Yeah, I'd just like to see a show of hands. Damon, I know you got your hand up, but before we get to that hand, maybe the left hand, how many folks have attended an actual mediation in this room? Okay, so quite a few, maybe half the room. I just wanted to get your perspective, Rachel, on mediations for those folks that have not attended, in terms of what to expect. What are they walking into? Is there going to be somebody hitting them over the head saying, "Give me a bunch of money"? How long? How does that kind of work? And how should they prepare themselves if they're not going to be attending with an attorney?
I think preparation is key. You want to know. We call it a case, a claim, whatever you want to know, whatever you want to call it. You want to know what it is the other side is asserting and what it is you're saying in response to that. You want to know all the facts, the players, key dates, documents. I think you want to have, as Anthony said, everything. You're going to have your file, presumably, for everything, and you want to have all your ducks in a row going into the mediation. I think going into it, you want to know what your strongest arguments are, and you want to know what the weakest points are. Because the other side is going to be bringing up the weakest points to the mediator, and the mediator is going to be coming to you and saying, this is what the other side is saying, what do you say? And so you want to plan your responses to that. So again, the weaknesses and the strengths of your case. So a mediation, again, it's just an informal day with the mediator. Usually you're going to be separated. You're going to have your own room. Sometimes the mediators will put you together, but you'll have your own room. Most of the time, the mediator will come back and forth to talk to the different parties. He will, relay the arguments that the other side is making and ask you for your response. As I said before, there's different kinds of personalities for mediators. There's some that are friendly and some that are very mean and will try to make you cry.
Yeah, I was going to ask, at least in the state of California, there is a purchase agreement that requires buyers and sellers to essentially agree on attending mediation if any dispute arises from that contract to purchase that real estate. So why would a brokerage or a real estate agent want to attend a mediation if it's just between buyer and seller?
So you don't have an obligation under at least the California purchase agreement to go to a mediation unless you agree to in writing, and you'll probably be asked to, and you can make a decision at that point in time. I think it's beneficial to go to a mediation if you know that a mediation is going on between a buyer and a seller, and you know that there is a potential claim that involves the broker or the agent. The reason being because most likely that claim will get, 90% of cases are settled before they end up getting to trial. So most likely at some point in time, the claim will be resolved. And if you don't get involved, the claim will be resolved around you, meaning that the buyer and the seller may, settle their differences. And as part of settling their differences, they may be throwing the agents under the bus. And you want to be, I think, at the place where the disputes are discussed so that you can be a part of the conversation, or so the agents or the brokers can be a part of the conversation and not left out and not be put at a disadvantage at a later point in time. So I think it benefits you to be a part of the discussion if there's a potential that the agent or the broker could be dragged in eventually.
Yeah, so in my experience, you'll have a buyer and a seller attend mediation. And they're there, they're hacking things out, and they reach a resolution. Now, the buyer is going to have an attorney, and that attorney is going to say, okay, you resolved with the seller, you got 10 grand, great. I got another idea. let's sue the brokerage and the agent because they also failed to disclose. They also had a duty. And so I can maybe get you another 10 grand or 20 grand or whatever it is. So you're now going to be maybe subject to this other area of liability and exposure, whereas if you had attended the mediation originally, you could have been a signatory to that original settlement agreement. So it's fully resolved against all parties. And you just want to be able to have that opportunity. And if it, you know, yeah.
And unfortunately, litigation always follows deep pockets closely. So, you know, you have any litigation, any claim going on between two people, particularly, you know, you take the seller and the buyer. Sellers and buyers may not have, you know, a lot of assets or a lot of things to go after. And a brokerage or an agent is going to be dragged in a lot of times because they know if they're not looking at the money, you know, backing the brokerage or the agent, they're looking at insurance money is what people try to find. So, you know, if a lawsuit has any knowledge of an insurance company that could potentially be involved, that person who's going to be the insured is probably going to be dragged in. That's just an ugly reality because, you know, you go through a litigation, you go through an arbitration, what that ends up getting you is a judgment or a decision. A judgment is only a piece of paper. So say you have a dispute with somebody and the judge says, yes, you're right and this person's wrong and you owe him $10,000. It doesn't end there. The person who should get the $10,000 judgment then has to go after the person who is supposed to pay them and try to find money that person has to get that judgment paid. And that is a long, drawn-out process as well. So if parties can, especially plaintiffs and plaintiffs' attorneys, they're very good at sniffing out insurance. If they know that they can get insurance involved, then they will, in any ways they can. So you'll be dragged in eventually, probably. So it's
I think that's
part of the early discussion.
Right, kind of a collections action there. So we have about 5 minutes left. We're going to open it up for questions. And afterwards, the three panelists will be outside for about a half an hour. So if you guys have specific questions or whatever it is, they'll try to help guide you through whatever your issues are. No legal advice is being given, though, however. Okay, so questions. Damon.
Okay, there it is. Regarding a claim, because as a broker, sometimes we'll get a letter from an attorney, you know, a buyer or whatever went and they have a friend that's an attorney and they just, you know, send over a letter. Is that what we're considering a claim, or is this a legal document that's coming over to get it up the chain of command or let our insurance, you know, company know?
Yeah, no. This can be this could be a simple email. I mean, there's no specific document that you need to be on the lookout for. Really, the law is notice of the claim, or the insurance coverage is notice of the claim. So whatever puts you on notice, as informal or formal as that may be, once you know that there's this claim against you, that's when everything gets triggered. And
it just becomes an issue of how do you define claim? Okay, so if you get a letter saying preserve evidence, in my mind that's not a claim, but there's a whole area a whole body of law that's called a coverage litigation, where you determine if there's coverage or no coverage. And there's lawyers that all they do is read agreements all day and interpret terms all day. That's a big legal world out there. I hate that world. I hate sitting there, you know, haggling and doing, you know, legal semantics type games. But for me, in my mind, and the way I've seen insurance company define claim is a demand for money. So there's something in a letter saying, I want $10,000 from you because you screwed up the thing. That's a demand for money. That's most likely going to be a claim. But the policy will define claim. They'll have a definition section that says claim means this. So, you know, it's kind of a gray area. And insurance is always going to lean on the side of, you don't have coverage for this. They're always going to try to figure out a way for no coverage. I mean, not always, but it's part of the game that folks, I don't want to be a pessimist here, but that's kind of the
If you ask an insurance company, they're going to say their obligation is to always find coverage. If you're going to talk to an attorney who's going to be battling with the insurance companies about coverage, you might hear
And I've gotten to those
like
battles.
That.
And I'll tell you what, when I was doing trial work at my old practice, we would put insurance companies on the stand, and because they would deny coverage for different reasons. And we would use their slogans against them. Sometimes they have slogans like, you're in good hands, or we'll be with you always, or whatever it is. Sir, my client was not in good hands when they asked you to provide him coverage. Isn't that right? And they, you know, kind of backfall on that one. So So yeah, so that goes for agents too. Sometimes I'll see agents advertise #1 in the community or #1 agent in this region or whatever it is, and they'll get sued and there'll be lawsuits. And I've seen attorneys say, now, ma'am, you advertise yourself as the #1 agent in this territory, right? And as a #1 agent, you know that you need to disclose every material fact, true. And they'll go down that route. So people will use words against you always, and that's just a part of the litigation world, and lawyers are just designed and trained to twist those things around to help their clients.
Alex, we got a question here, Ron, and then I'll get you up there.
Hello. In California, you know, our first part where we take our dispute resolution is mediation, and in our contracts, if we agree with that and mediation does not resolve the dispute, we go to binding arbitration. So what is your position for the California brokers? Should we recommend our agents to ask our clients to agree to that, or do we want to leave that open?
Are you talking about should the agents and brokerages agree to participate in the arbitration, or what should you tell the buyers and sellers?
Correct. What should we, if they were to ask us our opinion with respect to Section 22 of our RPA, should we agree to initial that and agree to that? Since if it doesn't get resolved through mediation, it goes to binding arbitration, and then if whatever is determined in that arbitration, we can't take it any further, correct?
Yeah, I mean, if you agree to binding arbitration, that's it, it's binding. So you agree to that process and you get to the end and you have a decision that can be enforced in a court of law. As far as advising, I think probably you don't want to advise either way, because whatever they always say no good deed goes unpunished. Whenever you would make a decision and you advise, if it goes south, then you're going to be the one that's blamed because it went south. So I think the best thing that you can do is you can tell them about the process. There's pluses and minuses to arbitration versus trial. I think you should always go to mediation. I think there's just really no downside to going to a mediation. But then the question is, what's next after mediation? Arbitration, or are you going to go and file a litigation in a superior court and go that route? I think probably arbitration currently, although it goes back and forth, is more cost effective at this point. It's quicker, depending on the venue. If you're in Los Angeles, for example, to get a trial date is going to take you several years. If you're in San Bernardino, it's much quicker. So depending on the venue, you could be waiting years until you get your trial, until you get your decision. In arbitration, I think you can get done and through within a year, pretty much, if everyone is cooperating and not, pushing back the date. So I think it's more cost effective. It's you're going to be paying your attorneys for less time if you can do it quicker. It's a little bit more informal discovery process. So discovery is the exchange of information before you get to the arbitration or the trial. In an arbitration, you're probably going to take less depositions and do less formal demands upon each other to exchange information. When in court, you're going to do that. You have more here in an arbitration proceeding. You have periodic hearings with the arbitrator who helps you push the case along. When you go to court, you may or may not have those hearings with the judge, and if you do have the hearings with the judge, they don't usually help you push the case along any quicker than an arbitrator does. And then the last thing, in an arbitration, you are going to be paying the arbitrator hourly for the hearing, but it's probably going to be less days. Usually arbitrations, you're going to see them in shorter time period than you're going to see trials. And there are a lot of fees associated with trials and costs. So
one thing I would just add, just to wrap it up, Ron, it might also depend on if you're representing the buyer or the seller. You might want to advise them differently. Sellers might want to get something more cost efficient. Buyers would not want to waive their right to just sue somebody and take them straight to trial. I mean, that's like the big fish.
Yeah.
One last question, and then we'll be outside to take other questions.
I feel like Donahue.
Daniel Collins.
So on the notion of twisting words, right? So occasionally in our industry, we get these disgruntled buyers or sellers who, like you said, want to blow off steam, just ranting away. They want to blame, and there's really no I don't know. You wanna protect yourself, but at what point do you back down and just kind of ignore them if they haven't really put a claim out? They're just saying, "I'm going to sue you. You screwed me over." Blah. And we all feel we've done everything right. But at what point do we either confront that or beat them to the punch and say, "I'm going to get my own attorney involved"? E&O maybe not care. I mean, what would you recommend? I mean, just every once in a while you get these just crazy people out there that they just want to fight.
Yeah, and obviously it's case by case, and it comes down to whether you think you can have a legitimate, reasonable conversation with them or not. I mean, if you think that it's worth your time and your effort to make that phone call or set up that sit down or go through the documents and say, look, you're claiming X, Y, Z. Well, X, here's all the answers to X. Y, here's all the paperwork that shows why you're wrong on Y. If you think that they can be reasonable and will be reasonable, and there's a chance that they say, you know what, you're right, my bad, then it saves a whole lot of headache down the road, right? But if you really believe this claimant is off the deep end, and whatever you show them, it's not going to matter, they're going to want to proceed, then I think at that point, that's where you need to roundtable and get your defense strategy and get your ducks in a row and prepare for the claim or the lawsuit or the mediation demand or whatever's coming. Because if they're telling you that they're going to sue you and they're telling you that you screwed them over, 9 times out of 10, they're going to go find a lawyer and actually prosecute the claim. Most people don't just abandon things, especially if they are one of those people who truly feel, well, one of the two, truly feel like they were wronged or they see a quick buck. So I think it depends on what you believe the likelihood of success of that conversation is.
All right. Thank you to our panelists. Excellent job. It's kind of difficult sometimes to keep a legal discussion, interactive and exciting, and we're not up here to, doing cartwheels and the whole bit. But it's I always tell folks the perfect broker in my mind, because a lot of you have the charisma, the personality, the people relationship part of it, and that's a given. That's very natural to everyone in this room, I feel. But if you can complement that with a compliance aspect of it, where you have a good understanding of the paperwork and some of the law behind it, what the CFPB is telling us, and just sort of stay attuned with all that, you've got a very dynamic broker that the sky's the limit for them. So it's a necessary evil, I guess, to understand this part of the brokerage world. So thank you again.
Thank you, guys. I appreciate it.